This is David Parker with the Law Office of David Parker with another entry on my video blog. Caregiver travel tips. Sometimes you travel because you want to, sometimes because you need to. Whatever the reason, planning a trip can be a logistical nightmare for caregivers. As a New York estate planning attorney, being responsible for an elderly loved one can mean adopting a rather rigid schedule and lifestyle, especially if you are the primary caregiver. How then do you travel? It can be a logistical nightmare, whether the travel is elective or necessary. Regardless, understanding some of the challenges and workarounds in advance can make the travel more manageable. The New Old Age blog at the New York Times recently offered some food for thought on this important subject. The big question is whether your elderly parent is traveling with you. If the travel involves you alone for business or pleasure, then you still may require the need to replace yourself while away. Perhaps you already have someone who assists with care. If yes, find out whether they can temporarily stay on full-time since they already know your parent and their needs. If no, then contact an in-home care organization, as many offer temporary services. Don't overlook assisted living or nursing homes, too. They might offer temporary stay options. Finally, there is the more difficult but less expensive option of coordinating a schedule of volunteer or recruited family members and friends. Note, care must be taken since everyone needs to know the schedule and understand the care requirements. If your elderly loved one will be traveling with you, such as for a family vacation or even to a care facility, then there are additional considerations, but at least you will be the one there to run interference. Of course, the first hurdle is whether they can travel. You'll want to contact their doctor to get their opinion. In addition, this will give you a greater appreciation of challenges you may not have addressed. While you're at it, medications ought to be first and foremost on your mind. Running low on medication mid-trip can be risky at best and deadly at worst. It may be difficult getting a prescription filled as well. It may be advisable to take extra quantities of virtually everything from pills to Depends. In regards to other details, making schedules for everything to maintain consistency from meals to rest breaks to bathroom breaks. Remember, when flying, consider asking for a wheelchair in the terminal even if it is not expressly needed. Why? The wheelchair can help make transporting your elderly loved one much easier, and on many airlines it can help you get to the front of the line when boarding. While the original post has even more specific ideas and instructions, the general rule of thumb is to think about the little details and to plan for them. Whether you're leaving your elderly loved one at home or you're traveling together, it will make a world of difference. I'm David Parker with the Law Office of David Parker. I'm an estate planning and elder law attorney. Giving and receiving, the charitable gift annuity. I'm David Parker with the Law Office of David Parker, and I'm an estate planning and elder law attorney. How does a retiree replace the interest income from a certificate of deposit paying more than 5% when the rate on a new CD is 1.3%? One solution: donating the principal to a nonprofit in the form of a charitable gift annuity in exchange for a lifetime of fixed annuity payments. Remember the good old days, when you could invest in a certificate of deposit, CD, and the bank would actually pay you something called interest on your deposit? No, really, I kid you not. Obviously, I'm being a little facetious, but you get the point. It's hard enough to make money these days, let alone accumulate wealth. When you're interested in a New York asset protection or any type of planning, as a New York estate planning attorney, there are some legal strategies that can assist you. Let's say you're retired and you're looking for a place to put your money to work, and you need more of a return on that money than the banks are paying on the CDs. Also, you are intending to leave a bequest from your estate to support your favorite charity. Here is a win-win idea to consider, especially if you are charitably inclined. Invest in a charitable gift annuity. Recently, none other than the Wall Street Journal ran an article on this very subject entitled "Earning Income by Making a Gift." Here's how it works. Give the money to your favorite charity instead of to your favorite bank. However, you may give and receive when you make the gift to charity in exchange for charitable gift annuity. Ultimately, you'll be giving what remains of that charitable gift to the charity at the time of your death. However, in the interim, you'll receive a fixed and predictable stream of income over your lifetime. The most important detail is that the annuity rate is determined by your age rather than national interest rates. That means a couple at age 65 would receive around a 4.7% yield, and a couple at age 75 would get a 5.7%. Individuals at age 65 and 75 respectively would receive even higher yields at 5.3 and 6.5%. Further, the money is tax-friendly. The yield is largely tax-free, and the initial charitable donation offers a sizable upfront tax deduction. Some savvy life insurance planning can even replace the value of the assets contributed to the annuity for your loved ones. How? With the increased return on your money via the charitable gift annuity, you may find enough left over to pay the life insurance premiums. A charitable gift annuity can help you support yourself, provide for your heirs via the life insurance wealth replacement and your favorite charity all in one fell swoop. Nevertheless, it can be a little tricky. Ensure that your charity can support a charitable gift annuity. Not all can. Look before you leap is a good piece of advice here. Check out the American Council on Gift Annuities website. But remember two important caveats. First, a charitable gift annuity locks you into that rate for your lifetime. So what is competitive now may not and should be national interest rates rise, the yield will no longer be as competitive. Some regard this as unlikely, especially in the short term, i.e. Ben Bernanke, chairman of the Federal Reserve, has said interest rates will be suppressed for another 2 years. Second, if the charity itself could suffer economic hardship and thereby be unable to meet their annuity obligations and cease payments. This is a real possibility. Charitable gift annuities are not backed by the government like CDs. Clearly then, if a charitable gift annuity is right for you, then it will take some research and proper planning to pull off well. You would be wise to seek appropriate legal counsel to help you analyze the appropriateness of a charitable gift annuity in the context of your overall estate plan. I'm David Parker with the Law Office of David Parker, and this is another entry on my video blog. I'm an estate planning and elder law attorney. Alzheimer's. Be prepared. This is David Parker with the Law Office of David Parker, and another entry of my video blog. Living with Alzheimer's disease is very difficult for the individuals affected and their loved ones. But by dedicating some early time on the diagnosis and fighting for the cause during World Alzheimer's Month and beyond, a family can know that they have done everything to support their loved one to live a full life and protect their legacy. You may not have known, but September is World Alzheimer's Month. As the month comes to a close, it is important not to forget about Alzheimer's. Medical research and advocacy are vital causes to uphold. Nevertheless, it is a disease that you and your loved ones might have to face directly, if you have not already. The reality of Alzheimer's or dementia striking close to home, and then some understanding and prior planning can help you in terms of the extensive economic toll and unique legal ramifications. According to a recent Forbes article, Alzheimer's is as widespread as it is demanding. Consider this: another American citizen will develop Alzheimer's every 69 seconds. The symptoms are oftentimes subtle, at least initially. Some estimate that more than 13 million Americans will have the disease by 2050 and run up as much as $1 trillion in costs. Because of the progressive nature of the disease, most of the costs and problems won't develop until later on. As a New York estate planning attorney, I know that significant planning must take place at the time of diagnosis, if not anticipated beforehand. So what is the scope of this significant planning, and how does it affect New York asset protection? First, you will need to secure medical care, both for now and for the future. That means fundamental financial planning needs to be addressed to include securing government benefits like Medicare and Social Security disability insurance. Second, because of Alzheimer's progressive cognitive degeneration, estate planning must occur early in the process to secure and protect family assets. Fundamentally, it is important to understand that Alzheimer's is not the same as other diseases. Through it all, competent counsel will be necessary to properly assess the needs and possibilities, as well as to ensure that everything is in place when needed most. I'm David Parker with the Law Office of David Parker. I'm an estate planning and elder law attorney. This is David Parker with the Law Office of David Parker, and another entry on my video blog. Patent Protection, the America Invents Act. Under the America Invents Act, we now have a similar 19th century style legal regime in which the fleet-footed, not necessarily the fleet-minded, are granted the legal rewards of exclusive ownership. If you're a small business owner and an entrepreneur, then you ought to check out the new patent law and the most major changes to it in some 60 years. With the stroke of a pen, President Obama recently signed the America Invents Act into law. You may not have heard much about it in the media because both parties agreed to it. While the devil is in the details and many remain to be seen, many regard the law as less than favorable to entrepreneurs. The biggest change is that instead of being the first to invent the system, i.e. where the patent rights go to whoever can prove they created the idea or product first, we are moving to a first-to-file system. Soon the patent will go to whoever gets the idea to the patent office first, and in a digital age, that is a race where every second counts. As a recent Forbes article points out, this is much more of a challenge to the entrepreneur, especially the technology entrepreneur, because it makes idea theft more likely. In turn, it forces innovators to be more closed about their ideas, out of fear. Prior to the new law, getting an idea right and getting it out there have always been a social process involving communication. For one, think of how dangerous a trade show might be for an entrepreneur. Similar systems have been in place in Canada and Europe for years, and there's evidence that it has not been good for small business. What to do? According to another recent article, this one from Smart Business, it's important to remember that you are in a race. Indeed, it's much like the land grabs of the early 19th century, and that's probably one comparison to a pioneer that an entrepreneur might like to avoid. It will be important to reassess how you deal with your ideas, whether you are an individual or you have employees working on developing their own ideas. You no longer have the option of sitting on a good idea. The lifeblood of small business is often innovation, and more so, the security of your business now might lie in speed. More information about the law and specific problems can be found in each of those articles, as well as in other sources. According to the American Invents Act, the race is on as of January 1st, 2012. I'm David Parker with the Law Office of David Parker. I'm an estate planning and elder law attorney. This is David Parker with the Law Office of David Parker and another entry on my video blog, Executors Beware. Being asked by friends or family to be executor of an estate is a big honor, but the warm feelings can vanish once the job starts. As a New York estate planning attorney, I know that choosing an executor can be a difficult task, and in no small part this is because it means finding someone you trust to do as you would do. Oftentimes it is a gesture of trust and respect made to a friend or family member. Neither the estate planner nor the would-be executor ought to forget, however, that serving as executor can be a fairly difficult role to play. The Wall Street Journal recently offered some practical insights and advice on the topic, noting that to be named executor is both an honor and a pain. Simply put, the executor administers a decedent's last will and testament through the probate, navigating the many twists and turns of that court process. Administration involves accounting for assets, paying for bills, and distributing assets in accordance with the terms of the last will. The process typically takes time too. It can mean up to several years for larger estates, and during that time the executor must keep up with the associated laws, tax code changes, and financial investments, or else intelligently delegate such responsibilities to professionals. It means that a non-professional can do the job, but perhaps not an amateur. You have to know your abilities and have confidence. To top it off, the compensation for being an executor is often meager, given the heavy workload, and is regulated by state laws. The biggest problem an executor will face, by and large, is a shifting relationship with the family. Money can make people antsy or even belligerent, even if the terms are clear in the last will, and that's something an executor might have to bear. This is especially true of family members turned executors who may face soured relationships at family functions. Accordingly, that can make for some awkward moments around the Thanksgiving table. Practically speaking, to serve as an executor, you must anticipate the challenges ahead of time, prepare for them, and remain organized. Indeed, organization is essential throughout the probate process to include separating yourself into two roles, executor and family member, friend. While planning your estate and settling on an executor, consider alerting your would-be executor your decision ahead of time. Doing so will allow them to prepare for the role and perhaps even get directions from you personally. For more advice and anecdotes, you can read the original article here, but to get a better idea of the challenges, it is best to watch some of the probate videos on my website. This is David Parker with the Law Office of David Parker. I'm an estate planning and elder law attorney.